Hello, everyone. My name is Kristen Bauer. I'm the head of policy here at the Chartered Institute of Arbitrators. I would like to welcome you all to this webinar on artificial intelligence in the legal sector, self-regulation essentials. This is the third webinar in the AI and alternative dispute resolution webinar series hosted by Ciarb and our wonderful partners, TrialView and JustMundi. The first webinar in the series covered AI and ADR fundamentals, where the group was really unpacking kind of AI itself and helping to demystify some of the technology. The second webinar covered global trends in the regulation of AI. And here the speakers were, covering off things like an overview of the recent EU AI Act, the Silicon Valley Arbitration and Mediation Center AI guidelines, as well as Ciarb's own forthcoming guidelines on AI and ADR. Both of those previous webinars in the series are available on our YouTube channel. So if you are joining us today, but you missed those first two sessions, I would encourage you to head over to the YouTube channel and check those out. So turning to today's webinar, we're going to be using our time today to zoom right in and look at really the practicalities of using AI on a day-to-day basis. So first, we're going to be looking at a range of technical solutions and AI tools that are available for practitioners. Next, we're going to look at some of the use cases and practical applications of AI in the legal sector. Then we're going to shift the discussion over to this idea of kind of self-regulation and explore some of the emerging good practices around the use of AI in the industry. And finally, we'll be rounding out our discussion by talking about costs, about skills, about training, and kind of some of the other considerations for how to really use these tools effectively in practice. So here with us today, we are very, very lucky to have us a very esteemed, a wonderful panel of experts with us. And so I'm going to pass it over to each of them to introduce themselves, and I will turn the floor over to Stephen. Why don't you kick things off? Stephen?
Thanks, Kristen. Delighted to be here. So hello, everybody. Thanks for joining. My name is Stephen Dowling. I am a director and founder of TrialView. I'm also a practicing barrister and commercial silk practicing out of Dublin. So looking forward to this conversation today. My journey in relation to tech has been one where I've essentially been seduced by the power of technology away from my day-to-day legal practice into into essentially a technology practice or technology company. And I'm very excited about the prospects of AI and how it's going to radically change our profession. But I'm also very conscious of the risks as a lawyer that we have to manage. So I'm looking forward to this conversation today. Thanks.
Thanks so much, Stephen. Annie, I'll turn to you next.
Thanks, Kristen. Good morning to all on the East Coast. I'm a Canadian lawyer and I'm based in Montreal. I'm currently in New York City. So for those who are up early, good morning. For those in the UK and elsewhere around the world, good afternoon. I've dedicated my practice to international arbitration, wearing different hats. I started acting as tribunal secretary I've acted as tribunal secretary in over 50 arbitration cases under the auspices of various arbitration rules and under various governing laws, working at the Permanent Court of Arbitration and with a very well-known Canadian arbitrator, Yves Fortier. I also joined thereafter a dispute funder, Omni Bridgeway, investing in arbitration disputes. And I am now head of Americas at JustMundi, which is a legal tech company operating at the forefront of artificial intelligence and dispute resolution and arbitration. I'm also a fellow of the Chartered Institute of Arbitrators, and I sit as an arbitrator.
Thank you so much, Annie. All right, now turning to Emily.
Hi everyone, I'm Emily Monasteriotis. I head up the International Dispute Resolution Group here at Simmons & Simmons. And obviously kind of AI is changing our day-to-day life. So one of the things that I'm really passionate about is really creating that culture of innovation in a substantial law firm. I think the opportunities that AI brings are absolutely huge, but we need to be able to harness them. And that's kind of one of the key challenges that I grapple with on a daily basis.
Excellent. Thanks so much, Emily. And finally, last but not least, I'll turn it over to Omar. Omar, can you hear us?
Yes, sorry. Yeah, I couldn't find the audio thing, right? So, good morning, good afternoon, everyone. I am I'm thrilled to be here today. I've spent over 2 decades in international arbitration, working with firms like Quatrecasas and Skaden across Europe, the US, and Asia. Currently based in Madrid, Quatrecasas doing only arbitration, and I'm very much focused on integrating AI into legal practices, as you will see, as a powerful tool in dispute resolution and decision making. And we're here at the firm, we are mad about technology, and I am the matter of all of them. So thrilled to be here.
Excellent, excellent. Well, thanks so much to all 4 of you for joining us. We really greatly appreciate each of you taking the time to share your expertise, your passions, your reservations about some of the developments in this field. Really looking forward to the discussion. So just a bit of housekeeping up top to take care of really quickly before we dive into our discussion. So first, this webinar is being recorded, and the recording will be available on our YouTube channel following this event. Sounds like early next week it will be available there. Second, we generally spend about 45-50 minutes in discussion, and then we'll leave about 20-30 minutes at the end for general Q&A. But that said, we really want this discussion to be interactive. So for all of our participants who are online with us today, we have a couple of ways that you can interact with this whole group. The first one is we have a chat box function available to you, and we encourage you to use it. You can, add comments, questions, ideas, have discussions inside of that chat box, and our speakers here will also be able to engage with you live in that chat. We also have a question and answer function available. So again, if you see on your Zoom screen, there is a space for you to add questions, and we encourage you to do so at any time throughout the discussion. And I'll be monitoring kind of both the chat and the Q&A, and I will do my best to integrate some of your questions and comments into our general discussion. And then finally, we'll be also using the Zoom polling function to ask you a few questions. So right now, I think you should be able to see the first poll pop up on your screen. So these polls just help us get some real-time interaction with all of you. So this first poll says, select which option or options best describe your role in the legal sector and or alternative dispute resolution. So I think you have some options there as neutral, kind of arbitrator, mediator, adjudicator, role as an expert, acting as counsel, as student, as an other. And this will just help us get a sense right off the bat of who is kind of online with us. So we'll leave that open for just a few more seconds, and then we should be able to see the results here. Okay, so we have a really mixed group online with us here. We've got about a little over, 36% are neutrals. Then we've got 20% experts, 25% counsel, 20% students, and 8% other. Excellent, a really mixed group, which is great to see. And I know many of you in this industry are wearing many hats, so I'm sure that this is also not a closed list. So you should be seeing our second poll come up now. This one is going to tackle sort of your familiarity or understanding of AI. So poll 2, so how often do you use AI-powered tools in your practice? So you can make a single choice here. This will just give our speakers and all of us an understanding how you're already using some of these tools in your everyday work. So you can select never, sometimes, are you using them 1 to 2 times per week, often, pretty much daily, or always. You never go anywhere without it. Sounds like that's Omar in our group for sure as the tech champion in his firm. So let's see what the results look like. Okay, so again, kind of mixed. So we've got about 36% of you saying you never use any AI tools. That's really useful information. And none of you are always using them in day-to-day practice. And then we have the rest of you kind of somewhere in the mix. So super helpful. I think that's really, really interesting. And thanks for participating in those polls. So without further ado, I think that gives us a little bit of a sense of who's in the room with us. And I'm going to turn things over then to Annie for the first question. So Annie, can you help give us a sense of, kind of an overview of the legal tech and AI landscape? Help us understand what are some of the tools available, and maybe what are some of the categories, or can you help us outline a sort of taxonomy of these different types of tools and solutions available?
Absolutely happy to, Kristen. I attended about 2 months ago the Legal Innovators Conference in San Francisco, and I must tell you that there's so many new legal tech companies popping here and there, coming up with new AI or Gen AI powered solutions for applications in the legal sector. And it is difficult for users to navigate this the market at the moment because there are so many new players, new entrants. All these players see obviously the possibilities and the business advantages, right, of launching these types of tools. There are so many great applications for Gen AI, especially in the legal sector. And so what I prepared today, I prepared a couple of slides to, try and help you navigate a little bit the market and understand from a macro level, what are the types of tools that are out there, hopefully to help you navigate what's on the market. So here on this first slide, thank you for sharing the slide. So here on this first slide, what we've done at Youthmundi, we've mapped out here a little bit the market and the types of players that are out there. There are many more players, but this is just kind of the main ones. You have two types of players, the players on the left-hand side and the players here on the right-hand side. The players on the left-hand side are players that only interact with a law firm's own internal data. So those are the Harveys, Leia, Luminance, Copilot. There are others out there, but those are the players where a law firm kind of uploads its internal documents to the system, and then they can ask questions. So it's for drafting pleadings, contracts, document analysis. You can upload so many exhibits and see the fact patterns, or create a factual background or history or chronology. So these are the types. So the players on the left-hand sides are the ones dealing with a law firm's internal proprietary data, and those are really kind of new entrants in the market. On the right-hand side, what you see are the more traditional players that deal with external legal data, so data or information coming from national courts, national systems, or coming from in the international sector, treaties, awards being published by various arbitration institutions, which is the case, for example, for Youthmundi. The players on the right-hand side some of them are starting to develop their own internal kind of Gen AI product to allow lawyers to carry out legal research in a more effective way, in the sense that rather than inputting keywords and using filters to get legal research response, now what you can do is simply ask a question to a chatbot, and then it will search through the database of that provider, and it will provide you with an answer in writing with footnotes. Some players on the right-hand side are adding that function, right, to their offering. But for example, at Youthmundi, and others are starting to do that as well, we are also adding a feature where a law firm could also include their own proprietary data to the system so that a user can then interact with both external legal data for research purposes, but also their own firm's proprietary legal data for drafting, document analysis, etc. Obviously, I think over the years, what we'll see more and more is a rapprochement between the players on the left-hand side and the players on the right-hand side. And what we're seeing already in the market is some M&A activity already back in 2023. And I showed this on this slide. We had Thomson Reuters, which is a traditional player on the right-hand side, acquire Casetext, which was a new entrant player on the left-hand side. So they've now combined and joined forces. Same thing with Vlex. Vlex was launched, I guess now 20 years ago. It seems like a more recent player, but it is. It was launched about 20 years ago. Player on the right-hand side for legal research, acquired Fastcase last year in 2023. So those, I think this is just to give you, I guess, a basic understanding, a little bit of what's happening in the market and the activity we're seeing on the market in terms of use case and in terms of M&A activity. Obviously, some law firms are also helping some of these providers develop, right, their solutions, because they have so much proprietary data internally, and they have the experience and the knowledge. Sometimes some firms are taking stakes in these companies because they are lending a hand in the development of these Gen AI tools. So if we move to the next slide, thank you. So as I was mentioning, there are so many tools out there. How do you figure out, navigate, and decide which tool you would like to adopt for your practice? I'm not going to go into, there are more than 200 tools out there. I'm not going to go into each one of them, but I wanted to give you a starting point for you to understand what types of solutions are out there. And a good starting point is this website, www.legaltechnologyhub.com. It's a fantastic website that lists a number of Gen AI providers out there. If you look here on the left-hand side, you can select various types of filters in order to determine which type of tool might be useful to you. So you can go by audience type, or you're a lawyer, counsel, or you're an expert, or you're an arbitrator. You can select those filters there and then start navigating and seeing, okay, what are the types of solutions out there that might be applicable to my practice? You can also select by the filters, include language, product type, practice area, the region served, and the type of deployment as well. Is this, are these solutions on premises? Is it cloud-based? Is it a web app, or is it an API, for example? So if you move to the next slide. So here I've taken the example of Harvey, which is a provider that most of us would know, which is now a provider that is part of those players on the left-hand side on my initial slide, so dealing with a law firm's internal proprietary data. So I just wanted to showcase here on this slide how exactly the information is a bit presented on this Legal Technology Hub website. So for example, it's very useful because for each of these tools, they will list the areas of use. So what is the target audience? What is the practice area? Here it's neutral, so it really applies to all types of practice areas. So this is a generalist tool. It's not a specialized tool for a specific practice area. And then on the right-hand side here, you see, the details. So how, this is an AI legal assistant. It's Gen AI or LLM based, the type of deployment. Here, I'm not a subscriber to Legal Technology Hub, so that's why you see the some of the features locked here. But security, how is security guaranteed? By the tool, and some information on the data hosting locations, which might be useful for GDPR purposes, right? On the next slide, I just wanted to showcase here a little bit, again, what you can see on Legal Technology Hub. You get a very good overview of the tool, what it can do for you in terms of, types of use cases, how you can use these tools. And then what's also interesting on the right-hand side, you can have some news around the tool. Some of these companies are new companies, so and they are still raising capital. So you get a sense as to where they are in their trajectory in terms of developing product as well. And then if you move to the next slide, you also have this fabulous feature on this legal technology hub, which is a comparison tool. So they will, so the hub will push some tools that might be comparable to Harvey. So, and then you can click and compare. We'll give you a comparison chart between, what Harvey, for example, provides and what are some other providers providing as well. And then finally, on the last slide, I just wanted to showcase us, at Yousemundi, we are, we just launched actually our Gen AI product last week at IBA in Mexico City. And I just wanted to share with you, we are a specialized product in arbitration. And I just wanted to showcase a little bit how our product team was thinking about, how we developed the tool. And the way we did it, we decided to, in combination with the lawyers working internally at Yousemundi, we decided to map out exactly what is the workflow right of an arbitration case, and where could Gen AI help at each and every step of a case. And so here, this is the mapping we've done internally at Yousemundi. I just thought it would be interesting for users to understand how we develop these types of tools. So here we mapped out, all the various stages. So from client consultation to case assessment, case preparation, the filing, the preparation of the evidentiary hearing, the actual hearing, and thereafter enforcement proceedings. And at every step of the way, we've mapped out exactly, okay, how will a lawyer work? What are the types of use cases that might be useful for a lawyer to assist lawyers in preparing arbitration cases. So at the moment, for example, obviously we cannot do everything all at once. So we decided to focus. Everything that's in green, for example, are things that we've managed to develop very quickly. Everything that's in orange are things that we are working on, especially professional search. I think is going to be a very powerful tool moving forward. If you're looking which arbitrator decided these types of issues in favor, in this way or that way. I think, these are things that, our users are asking us already. How can we do this with your tool? And so we're fully developing these types of applications. And everything that's in black are use cases that, we want to work on in the more, short to medium term. So just wanted to share that with you, just so for users to understand exactly how we think about, product development, especially as it applies to arbitration.
Thanks so much, Annie. Super helpful to get a sense of what tools are out there. I think in particular, the legaltechnologyhub.com, really useful platform for, for ADR professionals to start to get a hold of what's out there and where in the disputes lifecycle they may consider, integrating some of these tools. And I see here a question or a chat comment from Shobana Iyer, who is saying, AI tools, I'm kind of using this broad term, but she says, I suspect we mean generative AI as, a simple search engine is now an AI tool. So I'm sure we'll get into this a little bit more later, but super useful because it can be confusing as to what are legacy tools, what things are being kind of upgraded and integrated, or integrating, I should say, AI into their existing tools, and which things are new kind of innovations that practitioners could consider. So I think this segues nicely into sort of thinking about those use cases, diving in a little bit more practically again to what's happening in practice. So I want to turn over to Omar and see if you can help, provide some more examples of what you're seeing, how AI tools are being used, kind of day to day by ADR professionals, and what's the kind of things you're seeing happening within your own practice. So Omar.
Sure, thank you. So yes, we use it for for chronologies, for summaries, for all that kind of thing, of course, and it's very useful, right? But we use it for a lot more than that, right? And data retrieval is nice. We use it for that. It's powerful, but it's more powerful as a reasoning engine. And this is controversial, but stay with me. So in what I do, right, is, I use it to identify strengths and weaknesses in arguments, in reviewing expert reports, and I ask Harvey or any other AI identify weaknesses and gaps in my expert report so that I prepare for that in advance. And I will even ask the AI to help me with coming up with cross-examination, taking the role of opposing counsel. And I will be very intentional and detailed in how I ask, leading questions up to 2 levels, imagine the answer, blah, 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 right? So basically what you're doing is you're using the machine as a sparring partner, if you like, right? And it never gets tired, by the way. So if you think in that line, right? In that line is, you are developing in essence counter arguments, right? And traditionally, when you produce a few well-crafted counter arguments, this is time consuming, right? But with Gen AI, we can now generate not just 1 or 2, but up to 100. Probably we don't need 100 really, but at nearly 0 marginal cost, right? And this is, I think, what is disruptive. It's not just generating this, right? But what you can do is now you're exploiting the generative capability, and now you embed into the system evaluation schemas to actually tell the machine, look, out of these 100, right? Now I want you to assess these ones based on logical coherence, alignment with legal precedents or persuasive strengths. And now that you have done this, now come back to me and tell me, the best 3, right? So we may not need 100. There may not be 100 at all. I don't think our life is so diverse when we are trying to solve legal problems, but you see what I'm coming at, right? It's the exploitation of the generative capacity and then the embedding of evaluation schemas is basically 0, right? So that's for instance one of the great things we are using at the machine. Yeah.
Can I add something?
Please.
Yeah.
Can I interject? I think Omar, that's a great example, and I think you're referring to in advance of filing a reply or a written pleading. But there are applications as well of Gen AI during a hearing, and actually the Brazilian branch of the Chartered Institute of Arbitration did a moot case where on the one hand side they had classical lawyers, and then on the left-hand side of the hearing room or respondent, or I don't know which side it was, but they had lawyers but working with Gen AI live during a hearing to and there was a fake witness, it was a moot case, but trying to see the gaps of what was the witness saying or what he or she had said before or in their written witness statement. And so, you can use it live as well, right, during a hearing. And I don't know if you've done that, Omar, or not, or if you have any experiences to share with that, because I'm only aware of this moot case that that Brazilian branch of Ciarb did. But
so I have done this actually in cross-examination. So I prepare in advance the files. I uploaded the files. I went through some reasoning iterations with the machine as to make sure that the machine is understanding what I'm coming at, and I develop very detailed prompts. And I have done my work in advance, right? Like any of us, right? When you're going to cross-examine somebody, right? You know the file better than anything, right? And yet there will always something, right? Come up something, and the machine is good at that moment in time where you are able to ask and potentially help you in asking that thing that you may otherwise not ask because you don't know what is coming at you. So I'm just saying that that is already there. The capacity, I mean, the capability is already there. So it's clearly possible. And yeah, absolutely, yes. And I mean, I have done this already.
And do you need to disclose that to the arbitrators?
Potentially, yes. Yeah, I mean, I think, it's just fair that you do that, right?
Yeah, very, very, very interesting, Omar. And yeah, this is just a fascinating use case, I think. We'll come back to this issue of disclosure because I think that's right at the heart of thinking about self-regulation and transparency and, kind of safeguarding some of the risks around using this. But I have a question for you here in the chat. You mentioned you kind of scan the documents and you're getting prepared for your cross-examination. So we have a question here from Simon in Perth, Australia. He says, do you need to rescan the documents for these tools or will native files and PDFs suffice? So what's been your experience with that?
That's for me, right?
That is for you.
Yeah, you don't need to rescan anything. These machines, they can read anything you throw at them, basically, and they're becoming really, really good at going through PDFs in particular. They process PDFs really well.
Great. Yeah, fascinating use cases. I want to turn over to Stephen because I think Omar mentioned some of the kind of maybe use cases that are slightly more familiar, very interesting around kind of oral advocacy and cross-examination, witness prep use case. But what are some of the overlooked or underutilized uses of AI that you think ADR professionals and legal professionals should be exploring?
Yeah, I think actually what Omar touched up on there actually is very important. So as a litigator, I think one of the major game changers that LLMs will bring to the table is the facility to identify consistencies and inconsistencies in both, not only with respect to legal submission, but actually with witness testimony and factual testimony about particular events that have occurred in the course of the history of the litigation. So just to kind of put things into context, the challenge at the moment with AI is, in fact, the facility to chunk up and analyze huge volumes of data. So at the moment, the tools that are out there, for example, I think Harvey was mentioned as one of the examples. With the tools that are out there, what they do at the moment is they're very good at analyzing documents, which are maybe 50 documents, maybe 100 documents. But when it gets to serious volumes of documentation, I'm talking about hundreds of thousands of documents, it does run into a limitation. That limitation is known as the context window. But there are now ways and systems to be able to deal with that massive context of information. And obviously, I'll mention that TrialView is doing that at the moment. TrialView has ways of chunking up that data so that you can actually analyze very large volumes of data and specifically analyze it with reference to key facts or events or topics in a piece of litigation. And that opens up a whole new world in terms of preparing for trial and also to, for example, cross-examine witnesses. So a simple use case, which we currently are using in TrialView, is the facility to do a consistency check on your own witnesses in advance of going into trial. And depending on what legal system you're in, but a lot of legal systems tend to have either a witness statement or a deposition in advance of going to the hearing itself. And what the technology now allows you to do is to run a consistency check with your witness or the witness statement against the evidence that's in the case. And the evidence that's in the case, generally speaking, will be all the communications which that witness was privy to, any documents the witness may have authored, many documents the witness may have received. And you can actually run a consistency check so that if you take any key assertion the witness has made about certain events, it can check that against the underlying documentation to see whether or not there is an inconsistency. Maybe it's a date inconsistency, maybe it's a time, maybe it's a geographic inconsistency with what they're saying. And you can actually sense check that in advance of trial. You can also then use it on the other side. So when you do see the witness statements from the other side, and again, factual material is very, very helpful. When the witness statement comes in, you can run a consistency check against all the documentation that's in the data set. And you have to remember now with litigation, I mean, it's more prominent in the common law jurisdictions than the civil law jurisdictions. But you do have these massive data dumps in terms of disclosure and discovery. And that's where I really think that the LLMs will come into their own, and they can start analyzing all of that so that you can actually, instead of even asking your witness what happened, you start with looking at the documents first, because often the witness's recollection is completely unreliable. And really, at the moment, doing that we do that manually, or we do that physically, or we do it with people. The cost of that is just exponential, out of control, particularly in common law jurisdictions. That's a major area where I see a huge gains to be made. So that's a potential example of not necessarily overlooked, but I think that's really where a lot of the focus is going to come into sharp focus in the near future. And I think clients will start demanding that as well. I think we're going to see clients say, well, why am I spending hundreds of thousands of pounds or euros or dollars on this discovery review or disclosure review when we might be able to get AI to do it at a far cheaper cost? So it's that facility to have all the evidence in one place and to analyze that. I think that's going to be the real game changer.
That's fascinating. Yeah, definitely see some real shifts in maybe how the work is done going forward based on what you just described. I mean, I think what strikes me, and I'll just open this to the speakers, is, kind of based on what Annie said, what Stephen said, what Omar's just raised about how things are changing. I mean, how do you see this changing the industry? I mean, what do you think is, I mean, you don't have a crystal ball, and it's hard to sort of, pontificate too much about what paradigms will shift, but I'm curious to hear from all of you about how you really think this will change the workflow. How will this change dispute life cycle and the ways in which professionals engage in it? Open to anybody. Sorry, I'm off-pisting.
Well, I'm happy to take a first stab at that question, that loaded question.
I know. Thanks, Annie.
I think Gen AI is still a baby, right? The technology is still evolving, and as it continues to evolve, it will be able to tackle even more complex legal tasks moving forward. So with time, we're going to see the technology helping lawyers that are perhaps more experienced at the partnership level. I think at the moment, Gen AI is very good at these translation, summarization tasks, finding inconsistencies and things like that for legal research as well. And I think what we're seeing is productivity gains within the paralegal junior associates kind of levels within a law firm. But as time goes by, I think we'll see shifts percolating in other, through the entire workforce within a law firm. There are some studies that came out. PwC conducted a survey about a year ago now. And the survey indicated that initial analysis of these Gen AI tools increase productivity by 15 to 25%, and the 25% being for paralegals and junior associates, and moving up the ladder, obviously 15% would be more for senior associates and perhaps partners. But as time goes by, I think we're going to see those numbers increase.
One other area I think is going to radically change litigation is I think, and this is bad news, I think we're going to see for trial lawyers like me, it's bad news. I think we'll see a lot more early resolution of disputes, or certainly a lot more insight into the way a dispute might unfold at an earlier stage. I mean, there's various ways you can look at that. There's some predictive models that are in place potentially as well, where you can look at what judges are likely to do in certain scenarios, and you can look at the macro level, which is interesting. But I think the really interesting area is doing early case assessment. So traditionally, and I know this again as a litigator, you would give advice to the client as to the likelihood of success or failure. And usually that advice at the early stage of litigation is not particularly useful because it's largely hedged with major assumptions. And you make clear those assumptions. You say, well, if the witness says this, we'll win. If the witness says that, we'll lose. It'll depend on the credibility of the witness. It will depend on a number of factors. And really, it's a stab in the dark because you don't have all the information. And that's the problem with litigation. It's basically a step into uncertainty. And I think with two factors, one is the explosion in data. That means every company, every litigant now will have a repository of material internal to them. They don't have to get it from the other side. Internal to them as to what occurred in terms of Slack messages, WhatsApps, emails, video, etc. And secondly, the ability to analyze that at a fraction of the cost that was previously allowed or previously available. And if you can make that assessment, it could be a rough assessment at a very early stage of litigation. It means that the lawyers will be able to advise based on much more certain factual matrix, which is far more likely to transpire. And that will allow clients then to make decisions much earlier on as to whether to progress with this litigation or to settle early. I think it's going to lead, the early case assessment scenario will lead, and not immediately, but in the next 3 to 5 years, with a substantial radical change in actually the progression of litigation. Decisions will be made a lot sooner potentially. And that's going to change the economics then of litigation as well.
I totally agree on this, Stephen. And just recently wrote a piece on predictive analytics in international arbitration. And so I was, just trying to analyze how predictive analytics is going to have an impact, right? And I can imagine, right, like in a few months, my client coming with a report from whoever, telling the client, look, 79% you are going to lose, right? And then, Omar, what are you going to do about it? And how is the CEO going to explain to the board that he wants to spend whatever amount of money with me when the AI says 79%, you're done, right? So that is the early case assessment, right? Now, I mean, we need to think about this, but we also need to be conscious that there is so much of what we do that cannot be quantified, right? How many of us have been in a case, and I can tell you, it's my case. I remember this particular case where 5 days hearings, we are just killing it, right? 5th day, the expert comes and he doesn't do a great job, So, and basically we are done, 4 days killing it, 5th day, no, it's not going well. I mean, AI doesn't know about this, really, doesn't know how well counsel is going to do it, the witnesses, right? So, I mean, not try to oversell my services really, but I mean, we still will have a job in 10 years or 20 years. There's not everything can be quantified. That's my take on this.
Great views from all of you, and I think it's yeah, some interesting trends happening, and I totally agree. I mean, there's a court backlog a mile long in most jurisdictions, so I think there's not an issue with folks having work or being out of work anytime soon. Okay, so I want to turn now to this question of self-regulation, some of the emerging best practices. We've heard a little bit about some of the tools available, some of the opportunities, but I think all of us know that by now that technology is not a panacea. It's definitely not a silver bullet. It comes with all kinds of risks, and it's much more like Pandora's box in reality. So Emily, I want to turn to you now to seek or to ask kind of what are some of the challenges that you've seen legal teams or professionals face when they're first trying to integrate AI into their practice and into their kind of daily work?
Yeah, I think it's really interesting, isn't it? Because I think thinking about effective change is really, really hard, but kind of persuading others to embrace that change, I think, is a whole different challenge altogether. And I think when you come to kind of building that culture of innovation, getting people to adopt AI in a law firm is an even harder task. And there's some really great research that I'd really encourage you to read by a guy called Larry Richard. And he's a leading expert on kind of the psychology of lawyers, which is quite an interesting kind of career that he chose. And he's done such extensive research using kind of various kind of psychological assessment to study essentially the personality traits of lawyers. And what his findings all suggest is that lawyers as a group of people have some quite, let's call them distinctive personality traits that really kind of set them apart from kind of the general population. So for example, according to Larry Richards, lawyers tend to score really highly on measures of skepticism, autonomy, and urgency, and pretty low when it comes to sociability and resilience. So as a norm, lawyers are people who don't like to be told what to do by others, so they like to be autonomous. They question the need and base for change, so they're skeptics, and we want change to be delivered tomorrow or yesterday. So when we get it, we have this kind of sense of urgency, but we take setbacks kind of poorly and we don't really want to engage to talk about it. So, I mean, obviously that's kind of probably cliched and overstated, but I think it kind of shows that, I think for me, the biggest challenge is oneself and kind of overcoming that mindset and appreciating that you don't get perfection with AI. And I thought it was really interesting actually when we ran the poll at the beginning that 36% of people on this talk about AI have not used AI. So I'm kind of hoping that by the end it will change. But I do think the single biggest challenge is that human mindset, and it's shifting that and kind of trying, and it's kind of one of the tools that we use, but it is absolutely fundamental and is changing our day-to-day life. And I think the point that Stephen was making earlier about how you can have some early case assessment based on a really kind of far more detailed, in-depth review of documents pretty early on is shifting how we change and how we approach cases. So yeah, that was kind of my short answer.
Yeah, fascinating.
Just can I just jump in there? Emily said, I think I listened to Emily before about the profile of the lawyer, and I couldn't agree more. And I'm kind of hopeful that I don't quite fit into that bracket, but I think I understand the mind of the lawyer completely. But one of the things that we are as a profession, I think we're very conservative, and therefore we won't move into tech too easily, and we'll be the last to change. But one of the big things about AI is this conversational quality about the approach. So in TrialView at the moment, for example, you can do two options to find something. You can go in and you can go into search by date, search by keyword, search by the bundle, go to these kind of mechanical steps to find the document. But you can also type in, please find me the following. And the amount of lawyers that choose that option over the more mechanical option, the result, in fact, is just the same. In fact, it's probably sometimes more accurate going through the mechanical steps because you're more precise. But the lawyers love the conversational quality, the facility to use language, because they are very literate and they're conversant, and that's their stock and trade, versus going through mechanical steps or technological steps to find what they're looking for. So I do think AI actually, finally, maybe might ultimately start transforming our profession, which probably has been kind of waiting to be transformed for the last 20 years. We're the last ones usually to change. So it is a potential change in the quality of the technology, which is very, very interesting.
And I think that's such an important point, Stephen, if I may say so, because you're right, that's how I use kind of our internal LLM Percy. And I always say, please, like manners are important, even when it comes to kind of LLMs, but that kind of interaction that you can have, and you try and think, oh, I didn't quite explain that quite clearly, I'll try a different prompt. I think it's that mind shift that actually encourages people to use it more.
Yeah. If I can add something to that conversation, I think you raised such an important point, Emily, which is, the expectations of lawyers using these types of tools. These tools are not perfect; they're not meant to be perfect, and the prompting is so important. You ask a question, you don't get the answer, the exact answer you want, or the tone or the format. You can still continue, interacting with the tool, say, well, I want this format. I'm looking actually more precisely for this point. Can you, and then you kind of start wide, but you narrow it down. It's so important for lawyers just to continue the conversation with the tool, but not expect, a perfect response. It's really meant to help, as a first draft. It's an assistant. It's not there to replace the lawyer, but it's there to help you get to that first initial draft or first initial response. Or
and I think the key is you've gone wrong pretty quickly.
Yeah.
Well, traditionally you don't. You wait for the memo to come back from some poor trainee or paralegal, and you think, oh, actually, I can see why they've gone down that route. If only I'd explained the question differently. Whilst now it's pretty instantaneous.
Yeah, that instant feedback, it's so helpful. But I think really that change management piece, and you said kind of creating that culture of innovation, I think that is such a critical, maybe a critically overlooked piece sometimes that particularly workplaces, maybe organizations don't often consider, which is that you really do have to create that culture of questioning, and that there's going to be a bit of that mindset shift in the beginning to help folks feel comfortable and to really start to use these tools in their everyday. So I think, we touched on this a little bit up top about some of the limitations, some of the potential risks, but Omar, I want to come back to you. I said I would come back to you on this point, which is, what are some of the potential risks that professionals should be aware of when they're relying on these tools? I think you kind of mentioned a little bit up top about disclosure, whether or not you need to tell the tribunal or your clients or others that you're using these tools for preparation, or be that preparing memos or research, or for your oral advocacy preparation. So I want to come back to you on that, Omar. Tell us a little bit about some of those limitations and risks, and what folks can consider to help sort of mitigate that.
Right. To me, there are so many risks, right? And using the technology, and I would refer to two that really concern me, right? So the first one is critical thinking, right? If we're not careful, clearly we're going to start accepting AI generated insights or conclusions without scrutiny, right? I see that happening. Look, I tell my teams, everything that you deliver to me, absolutely everything, is mandatory, needs to go through AI. Not that AI is going to do this. I want to know what the AI thinks, okay? And now, the same, I ask them, critical thinking. Think about this, the machine, doesn't know anything, really. It's not a database. It just waits. Like weights of information. It has learned all the patterns in the world and blah, blah, blah. But in effect, it doesn't know that the capital of France is Paris. It just doesn't know as a fact, right? It knows that in whatever it has seen in the patterns, like 99%, because there will always be somebody who says it's not Paris, people typically say Paris, but it doesn't know it as a fact. And this is absolutely of essence to understand how to use the technology, right? It will come up with something that clearly it reads fantastic the first time and probably the second one, but you need to go a lot deeper than that, right? So critical thinking for me is absolutely essential. And the second limitation or risk that I see is the black box or explainability, right? It is difficult to trust a system when you don't understand how it reaches its conclusions, right? By definition, you don't understand how the machine concluded what it concluded. You actually don't know. And it's interesting because we have papers, scientific papers. When they try to work on the LLM, they ask the LLM, how did you reach this conclusion, right? And the LLM actually lies, it will make it up. However, it's wrong It will make it up to you to justify itself that is right. And you're like, I cannot believe this, you know? I mean, you guys are you're killing me. You're lying to me, right? So there is no explainability. It's not explaining itself, right? It's just making up something afterwards. And that again goes to the technicalities of the machine, right? I mean, if you understand what is machine learning and you understand the whole limitations and the transformers architecture and the whole thing, oh, wow, yeah, exactly. The machine doesn't know anything, right? So the good thing is we have, exciting developments in robotics that actually will help us make the AI more explainable. And by that, and I don't want to, go too much into this, but, when you merge LLMs with sensors, and then you have a robot, basically, now the robot is able to explain, because it sees the world, in effect, with sensors, why I'm taking, this decision, because I actually see the world. And that's what it happens with LLMs, right? They don't know anything about the world, the physical world. And that's why when you ask the machine, my kid is 10 years old and he is 1 meter 2. My kid is 12 years old, is 1 meter 4. My kid is 25, how tall will be? 2.5. Oh, God damn it. Not really, right? So because it doesn't know the physical world. Now, through robotics, we're getting there.
Very, very interesting. And I think this paradigm that you've created on your team, everything must go. And then I think on the other side, everything must go through AI first before it comes to you. And then you see another kind of culture that says you can't run anything through AI and you have to sign, agreements that you won't be using it. Let's say I've seen this in law school cultures where, you see kind of extremes on one side or the other. Very interesting. I want to turn back to you, Stephen, to look at kind of, we've heard some of the risks and some of the ways you can mitigate that, but what does self-regulation really look like in this context? Do we have any good practices emerging or things guidelines that folks are putting into place within their organization or within their own practice that can help sort of create the right safeguards around using these tools in practice?
Yeah, I think the fundamental principle should be aligned with what we do at the moment as professionals, to be honest. I mean, you need to approach, as a lawyer, you've got professional obligations, and you need to approach what you're doing with the same ethical ethos that you always had as preparing as a lawyer. And in a way, there's not much of a difference if you take that as your kind of your pole star, your guide star. So the way I would look at AI is it's quite similar to working with a team. And if you're a senior lawyer in that team and you've got more junior lawyers, you need to be accountable for their work. So if you are, and then again, I'm speaking more in the context of litigation, if you're presenting an argument to a decision maker, to a judge or to a tribunal member, you need to be able to stand over that argument. You need to be able to ensure that the material you're presenting is accurate. You're not misleading the tribunal in any way. And you need to make sure, for example, that you are presenting the most up-to-date legal position that you're aware of. And if your junior lawyers you're the senior advocate and you're being fed that information by your junior lawyers, you need to make sure you've got systems in place to be able to quality check the information that's coming through to you, which can be challenging depending on the scenario. And I think it's the very same for AI. I think AI is just a tool. And if you're using it, you need ways to quality check that information that you're going to be generating from that. And that basically, I think at its bottom means verification. That anything where you are generating material where essentially maybe it's an argument, maybe it's an assertion. If that material or assertion has been generated using AI, you need to verify the source of that each time. I don't think it's enough even to be, I don't think actually at the moment it's even enough to say, well, it's generated by AI and I've disclosed it was generated by AI. I think what you need to do is be able to verify the source of that information. So your AI tool has to be able to provide verification. And that actually is a tricky thing. Technically, it's a challenging thing. but also it's tricky because most AI tools are based on a frontier model. A frontier model is like OpenAI or Claude. And those companies are not telling us precisely how the algorithms are working, essentially. So we don't quite necessarily know how, if a Gen AI analyzes a document, how it's extrapolated out the summary of that document, for example. But we do know the document, or we do know the sources. So we need to be able to kind of do that quality check. And that itself is, I think, the guiding star of self-regulation. Quality check it, essentially own the material as your own, use the AI as a tool to maybe do it faster, but quality check it. And then there's a balance, because if you are going back to the drawing board each time you use AI, then you'll lose the value or the time efficiency that it potentially gives. So the real, I think, answer to that is you need the right tools to allow you to do that quality check quicker. And sometimes, and this hasn't yet, I haven't seen tools that do this yet, but the future is actually that the systems themselves will quality check each, like there'll be an internal quality check. So AI will check AI, which is again helpful. I think it's a good thing because it can read what it's already said and check that against something else. But at the end of the day, we all have to take responsibility. And that in turn then means not only the lawyers take responsibility, but they also have to make sure that the suppliers of the technology are held accountable as well. So I think that's the kind of simple way to approach it.
Can I interject, Kristen, if you don't
Please.
mind? Thank you. You know, Omar, you raised the point of critical thinking, which goes to the point of the danger of over-reliance, really, on these types of tools. Stephen, you're talking about, you know, verifying the answers and the quality check. And I'm just curious to hear both of you and Emily as well on, you know, how can junior professionals, the junior associates that need to, you know, they need to train themselves on, you know, critical thinking, all of that. How are we going to train the junior lawyers, the junior associates internally at law firms to be able to do the quality check if they don't have the experience of obviously a senior associate or a partner? So that's something I'm grappling myself with, and I'd be curious to hear what are your thoughts currently within your respective law firms on that front.
Sure. Shall I go first? I think this is a real issue, right? And that's, we kind of constantly sit in meetings going, well, how are we going to train junior lawyers? I think the reality is, if we're being honest and realistic, is that their role is changing. And actually, the people that I need in my team are the juniors, who are the ones that are most technologically proficient. But I will use them in a different way, and they will learn different skills. And I don't think you can go back and say, oh, when I was a trainee, when I was a junior associate, this is what I did. We've moved on. And I really think we've got to really grapple with the point. But that doesn't mean that junior lawyers can't develop their own critical thinking. They're developing it in a very different format and in a very different way. And again, kind of years ago, 60, 70 years ago, there weren't, in order to find a case law, you couldn't go to a computer. You had to go down to the library, you had to find the right bit in the book, you had to take out your building law report or whatever it is. That skill died years ago. That doesn't mean that trainees then couldn't find case law. You just had to find it in a different way. And I think it's a pretty exciting time to be a trainee, actually, and a junior lawyer at the moment, because I think it's far more interesting. So rather than sat in a meeting, sitting there actually trying to take notes, you use Microsoft Copilot or whatever product it is that you want to use, and then you kind of analyze it in a very, very different way. And I just think we've just got to take a bit of a step back and realize that we've got to shift our mindset, which is, it doesn't mean that junior lawyers will no longer exist. I mean, to be frank, I think it is a bit more difficult when it comes to kind of armies of paralegals who used to review documents. But the world is moving on, and we've got to move on with it.
No, completely agree with junior lawyers. I think that their role is indeed, Emily, is slightly changing. What I see with them is they're very good at prompting. Actually, they really try. And what is happening, in fact, is that, for instance, I teach machine learning and prompting in the university to law students. So this is already embedded into the system, yeah. So the university has figured out we need these guys to understand the machine. And I'm doing 4 hours of prompting. I don't know what I'm going to do about that. But anyways, right? I mean, there is a need, and they want to learn. So it's just like a new internet, if you like. It's a different tool, right? And they are very fast at learning how to use it.
Yeah, that's the super helpful insights into thinking about what the kind of skills are that folks are going to need to be able to really effectively use these tools in their jobs. And so I think that shifts us nicely onto this last section. I wonder, Emily, I just want to pick back up on this piece about training. What are the kind of foundational skills you see, maybe mid-career professionals, folks who are already acting as neutrals or experts, or more senior practitioners? Are there foundational skills? Are there other things you think they should be doing? What kinds of training they should be looking at to kind of upskill in this new environment?
I mean, absolutely. And I think training is such a key part of this, because how do we differentiate ourselves from AI, right? What are the human characteristics that we will bring that AI can't do? And I think when it comes to training, there's kind of various different kind of aspects and different outputs that you need from your training. So key one is being technologically proficient, really understanding kind of the basics of AI and machine learning, how AI tools are developed and operate. That's really crucial. And basically everyone needs a nanny in their life who understands kind of all the different platforms and software that's kind of used and how they apply to ADR. I think that is really, really key. There's also kind of, we haven't really touched on it, but around the kind of the ethical and legal considerations. So kind of training in the ethical use of AI in ADR, issues of bias, confidentiality, data security, really understanding kind of the legal implications and the reg framework surrounding AI and dispute resolution, I think is important. And also how AI integrates and how that kind of interaction between human decision making and AI recommendations. And to do that, you really need to understand the limitation of AI and how intervention is necessary. But for me, the single most important part of the training, or the second most important, because obviously technological proficiency is really key, is kind of communication skills. There's honing in your presentation skills. So as AI kind of handles kind of more data analysis, we have to kind of up our game when it comes to communication skills in order both to interpret and explain the findings when it comes to AI. And I think that is kind of really kind of being a good lawyer has always been a given, but how you present yourself, I think, is really key. And it becomes even more important when you bring kind of AI into the mix. And my last point, which again is a really important point, is actually the concept of continuous learning. I don't think anyone's under any illusions. AI is here and it's here to stay. And it's that pace of change that I think really differentiates it from other changes that we've seen in our market. And a commitment to that kind of ongoing education and staying updated with the latest AI development and application in ADR is really essential. So you can't just go on one AI course, I understand AI course. It's moving, and it's moving at a pace. So that kind of changing again your mind shift, and sorry to keep using that expression, to the fact that I need to continuously learn and continuously keep up is really key.
Thanks so much. I'm feverishly taking notes, thinking about the ways in which, in our own work here at the Institute, we need to, consider our, training options and how we're meeting the moment. So super helpful. Okay, I want to shift on to another kind of practical element here around costs. Annie, this is a question for you, and then maybe also for Stephen to chime in. What are the, just as a practical matter, we have a lot of, you saw, about half the group I think here today is neutrals. Some of them may have a solo practice or a mixed practice. They may be working also in a firm. What are the typical kind of upfront and ongoing costs associated with adopting AI into your practice? And I'll wrap together sort of how can folks consider what the best tools to invest in are. I mean, I think given the fact that Emily just said, things are changing, we've heard that the industry's dynamic, it's shifting a lot. Can you speak to this group a little bit about what the costs look like, where they should be investing their kind of resources in this moment?
Yeah. So I'll answer the question vis-a-vis, from the perspective of external tools, because some law firms are developing their own internal tools. But if you're looking for external tools from external providers, at this point, it's obviously there are inherent costs that a provider, to develop the tool, to host some of the data on the cloud, perhaps, or even, some of these providers don't have their own algorithms. It's an algorithm, an LLM that is, provided by OpenAI, for example. So every time there's a query into their product, every time there's a prompt, then the provider has to pay the OpenAI, for example, for tokens, so that the users can interact with that LLM. So there are inherent costs, obviously, for the service provider, and the service provider, obviously, are private companies trying to make a profit. At this point, in the market, I think I think different providers are testing pricing. It's very difficult to, what is the price that a lawyer or an arbitrator, are prepared to pay for these types of products. But, from our, research of the market, what we see, is usually it's either, subscriptions, an annual subscription, usually, team-wide or firm-wide, but sometimes they sell individual licenses. And usually pricing is around $1,000 per user. It could be more, it could be less. It really depends on the provider. But I would say, as a general rule, I would say it's around that price. This might change moving forward, might increase, might decrease. We'll see how the market adjusts. And it depends also on the adoption rate. If the adoption rate is not there with that pricing, then maybe, providers will start working on pricing. So that's the cost of the actual tool. But I think what's important to note as well is, there's, I guess, inherent costs for arbitrators and lawyers, in the sense that, especially those still working on the billable hour fee model, simply because what we're seeing now in the market is, for example, the California Bar just issued new ethics rules. And those rules say that a lawyer must not charge hourly fees for the time saved by using generative AI. And the American Bar Association just issued an ethics opinion recently. It repeats the same, but it goes even further. And it states that in most circumstances, the lawyer cannot charge a client for learning how to work a Gen AI tool. And so those are considerations that, lawyers must think about. And this is for the US, this is for California. I don't know in other jurisdictions exactly what's happening, but if you're on the billable hour fee model, you might start thinking, well, maybe I should reshift my business model on a flat rate or contingency rate. I know some, arbitrators charge, depends on the arbitration institution sometimes, but, it could be, the value of the case, ad valorem. So those are considerations. Yes, you may wish to start adopting these tools because they help you in your everyday practice. But if, you have to think of these ethical guidelines, and if you cannot charge for the time saved, then you should start thinking, okay, well, how is this going to impact my business? And should I change my business model? And then in terms of which tool to pick and choose, to answer your second question, Kristen, I think, again, do your research, look at, there are some general kind of websites, and I've referred to one at the beginning of our discussion today. Speak to your colleagues, see what they're using. You can test these tools. Some of these providers offer free trials. You can test them, or sometimes, if they don't offer a free trial, they might offer a paying trial. So you can test the tool for a month and see whether, it enhances your everyday life and your practice.
Thanks, Annie. Yeah, I think this goes back to what Stephen touched on early on in this discussion, which is that the economics of litigation and arbitration, these tools are going to change the whole dynamics of that. So really interesting. Yeah, Stephen, go ahead.
it is very interesting, and like just to address the 2 points. One is, at the moment, what's it costing, and but how does it affect the overall economics? And what we're finding is our use case is probably slightly different. We're not a work product tool, in that we're not there to assist you to redraft documents, etc. Rather, our AI use is more for interrogation. It's more about finding relevant information and finding it quicker across a vast data set. And there, in truth, the cost of that actually can range from being relatively inexpensive if the interrogation is at a relatively low level or superficial level, to quite expensive. It's good if you are interrogating a vast number of documents. And ultimately, in those kind of scenarios, the model is the lawyers will pass that cost on to client because it's in a project by project basis in that particular scenario. But the real question is what is the value that's being delivered from the client's perspective? And we're going to have this potential tension coming up where the lawyers traditionally would have made a significant amount of money by virtue of putting reviewers or getting a massive team over a large data set and producing essentially irrelevant documents or isolating relevant evidence, versus potentially a big cost saving if they choose to use a tool. And so they may not be particularly incentivized in the near term anyway to use those tools. But my sense of that is that, unlike the past, where clients may not have been particularly savvy, or not savvy, but just not knowledgeable about the world of litigation, the world of disputes, and what tools are out there, I think clients will, probably already now, will start demanding that AI be employed in those kind of situations where costs can be saved, and because they know about AI and everybody's speaking about AI. So if you say the bill is going to be $200,000 for a discovery review, they're going to say, "Excuse me, surely AI can solve that problem." But there is another challenge, and I think it's an important one. We just don't know where it's going to land. The amount of investment that's taken place in AI, mainly by the frontier models, that's OpenAI, Claude, Amazon, Microsoft, etc., Facebook, Google, is in the tens of billions, and it's actually escalating. Costs are escalating. And the reasons for that is because to get the LLMs to the place they need to be to really deliver on the promise, we need more computational power, we need more investment, we need more energy, and that's very, very expensive. And there are some potential clouds out there which suggest that in order for us to, or for those companies to recoup their investment, they're going to have to basically charge a lot of money to get that back. And if that proves to be the case, and we don't yet know, it may actually result in a negative thing for disputes, which is that only the well-funded, the deep-pocketed firms or clients will be able to afford these tools. So I know 2 years ago when we were speaking about AI, we were talking about evening up, essentially allowing artificial intelligence to give the small man as such a fair crack at the whip. Whereas actually there is now a possibility that these tools, if they're going to be used to any great effect, will actually be very expensive. So that's still kind of wait and see. But there is definitely strong indicators now that in order to deliver the real value, the real promise, it's going to actually be very expensive.
And Stephen, if I may also interject, I think this is a really, really tricky area. And interesting, as part of a conference that I was speaking at, I did some research into the billable hour, and it was discovered or invented, probably is the right word, by someone in 1920, someone called Reginald Smith. So the billable hour has been around, and he created kind of the first timesheet. But we've got to be realistic. The billable hour pricing in law firms particularly is going to have to evolve, because, as you say, clients are sophisticated. Courts won't allow you to recover the cost from what Annie's saying. And I think the trend that we're seeing in the US is going to move. But I do think there has to be a basis of recovering the cost of technological investments, and that is the reality. So it's no longer in the interest of the law firm to not evolve the pricing model. So they're going to have to do it. But also just picking up on this issue, kind of like larger law firms and smaller law firms, because clearly firms at scale will have the advantage that you've been talking about in terms of the investment that they're going to be able to put into newer models. However, you've got to balance against that the agility of smaller firms may give them an advantage when it comes in terms of the pace of change and adoption. So actually, I think smaller firms have got quite a lot to gain at the moment, because they're going to be able to have that pace of change much, much quicker. It's just whether or not they can invest in the first place.
Very interesting indeed. I think I see that there's another webinar series in our future where we can continue these discussions. We've only got about 5 minutes left, and there are some questions in the chat, so we'll do a bit of rapid fire, and anyone who would like to take a crack at those can do so. So Simon asks, can AI also process voice recordings?
It can process anything.
Yeah.
Yes. Okay, and then there were some questions about maybe a little bit more existential about, to what extent this increasing reliance on AI is going to impact human critical thinking skills in the future. And I think, Emily, both you and Omar sort of touched on that. It was framed as a question, I guess, maybe what can we be doing? Or maybe back to Annie's point, how can we be training, upskilling younger folks in the pipeline with the requisite skills? And maybe we've already tackled that, but if anyone wants
I
to
should
chime
just
in.
say on that, the jury is still out on how much AI can truly reason. So, and I mean, the OpenAI just released Strawberry 01, which apparently thinks, but they say that with inverted commas, and it's which is essentially recursive. Well, I don't know if it's essentially this, but people describe it as recursive prompting. My view is that we are a bit away from reasoning, proper reasoning, and critical thinking, as the questioner has asked. I think we're a bit away from that, if it ever is to properly transpire. Rather, I keep coming back to this. I see AI as just an extra pair of eyes over those documents. It can basically see things that no human can see, simply because it has the capacity to scan so much information and bring that back. But reasoning, inference, we're not there yet anyway.
It's very useful insight. So turning now, it's saying, can you set parameters such as boundaries around jurisdiction so that you're not getting back, I guess, in your query, not relevant information, seeing nods?
Yeah, you just ask the machine.
That's possible. So it sounds like, Simon, this is to you. You can. I think this goes back to what Emily was saying in the beginning about or reacting around the conversational nature and sort of trial and error. If you're not getting exactly what you're looking for, or you're getting results that are not desirable, then trying to reframe.
And you have to understand the data input, and what is the data input into these legal service providers, right? So, for example, Jusmundi, when you're trying to do legal research, the only data you're interacting with is Jusmundi's database. You're not interacting with the Internet of Things, or you're not interacting with other sources of data. So you just need to understand what is the data that is inputted into the tool.
Exactly, yeah, and that is one of the problems with using AI tools that are generally available. They're not limited to a particular data set, whereas and this is where it's a little more expensive. The private AI tools that we're using in TrialView as well, same as Jusmundi, is you target it at, in this instance, the case, so the matter in question, the evidence in the case, but it doesn't go beyond that. It just only answers based on the documentation in that particular matter.
That's great. Yeah, super helpful to understand those inputs. Okay, there's a few questions here, which I'm just going to read and summarize. And then instead of answering each of those, I will give the floor to each of you 4 speakers to sort of conclude with your final thoughts on, kind of your key takeaways from this discussion and where you think things are going. So we've got one question about data breaches of legal AI supplier resources. How will this impact the field? Then there was a question around how much this will impact unemployment or I guess employment and generally and impact the jobs in this area or careers, legal careers. And then there is a question here: with AI's ability to analyze complex scenarios and generate multidimensional arguments, could its integration into legal proceedings potentially complicate cases by extending arguments beyond the conventional 2 or 3 dimensional perspectives that human lawyers typically consider? So really small questions for all of you to consider. You don't have to answer those directly, but I'm going to give the floor to each of you for kind of final thoughts, key takeaways from this discussion in your own words. So I'll turn first to you, Emily.
Yeah, I think the one thing that I want to flag is that according to Goldman Sachs, big study that they carried out, 44% of legal tasks are going to be replaced by AI. That's 44%. That's pretty huge. But I don't think that means that 44% of jobs are going to be lost. I think the reality is that different jobs will come into existence, and it's the opportunity now to grapple and work out how you can be part of AI rather than feeling threatened by it.
Great. All right, then back to you, Omar.
Well, I think very interesting things are coming. I'm very optimistic. And for the startups out there, what I want is a virtual legal colleague. Okay, I want the AI embedded into my system so I can talk to my dispute. I can sort of do that already, but I want more of that, please.
Omar's throwing out business ideas over here. Okay, to you, Stephen.
Okay, Omar, yes, your wish is my command. We're on the road to doing that, become your virtual legal assistant. I actually do think that the potential promise of all this is that facility where we can go back to being real lawyers again. But one of the problems, I think, with modern litigation is there's so much dredging through material just to distill down what are the issues in this case, what are the things I really need to think about and make my arguments about. And one of the promises of AI is to be able to use the tool to basically narrow down that factual matrix to what really is relevant quickly, and then apply what we learned in college, our legal skills, our reasoning, our ability to argue, etc., back to kind of the core roots of what being a lawyer is all about.
An optimistic view. I love it. Okay, Annie, final thoughts.
The last word of the panel. We're faced with, so much change is coming our way, right? And I think sometimes we need to go back to the Greek philosophers. And I'd like to quote Socrates. He said, "The secret of change is to focus all of your energy, not fighting the old, but building on the new." Gen AI is here to stay. Let's not fight it. Let's build upon it.
Thank you so much. And with that, that's a perfect place to close this webinar. Huge thanks again to our wonderful partners, TrialView and Justmundi, for helping to put on this webinar series. And tremendous thanks for this wonderful panel of speakers. Thank you all so much for sharing your wonderful insights with this group. And to all of our participants online, thanks so much for joining us today. Really looking forward to building and continuing the discussions. So thanks everyone, and have a lovely rest of your day.